door.
Hey, I'm Brandon Lee. This is the Luna Ultra. Major new feature is the detachable touchscreen remote control. This touchscreen lets you trigger focus as well as tracking. It can track people or objects. And you can also turn the power on and off, start and stop recording, and control the joystick and the zoom. So I could face the camera one direction.
Damn that quiet. We all hit that book. So
Judge, can I put these on? Yes. Thank you.
All right, let's get on the record. This is called number XY00154, Child State Offensive versus Hungary. Last week, both sides had rested for and court recessed to this morning to hear argument of counsel. Both sides ready?
Yes, Your Honor.
Yes, Your Honor.
All right, the record will reflect that both sides are present, the defendant is present, attorneys. All right, the state may proceed.
Thank you, Your Honor. Please, counsels. The evidence we heard last week, Your Honor, is the state's case on motive and the events that led to the charged offense. This case concerns a rap feud, Your Honor, between known Dallas rappers. Their feud was open, it was public, it was in social media, it was in their media interviews, it was through their music, and it was in the streets of Dallas. This offense did not happen in a vacuum, and the jury is entitled to hear about what transpired that led to one Dallas rapper placing a bounty on another Dallas rapper. While the state's filed a response that outlines every piece of evidence that we'd like to put into evidence, as well as the legal justification for it, I'd like to highlight some this morning, Your Honor. First, we've attempted to narrow down the list of items to only those that go to motive, the feud between the parties, and other evidence that will be corroborated by our grand jury witness and other witnesses. During this hearing, Your Honor, the court heard repeatedly the name Roy Lee Pate regarding how this feud got started. It's in the grand jury testimony, and Louisville PD even asked the defendant, does this feud have anything to do with Roy Lee Pate? And he said, I think so. Now, the shooting and the death of Roy Lee Pate will not be admitted as 404B evidence against the defendant who committed it. It's merely going to be suggested as the starting point between the feud between the parties. And we know that it has something to do with this feud because hours after his death, the defendant is shot while driving home multiple times. Louisville PD tells him the next day that the vehicle that pulled alongside of him belongs to the decedent's head of security. 2 months later, more Sprinter van is shot up. Now, both of these shootings are not extraneous offenses committed by the defendant. They are not other bad acts committed by the defendant. They are not 404B evidence. Rather, they are contextual, pre-existing events that led and explain why the offense occurred. They go to motive, Your Honor. Because 2 months after Moore is shot, or his Sprinter van is shot up, the decedent releases his song 219. And in that song, he makes certain declarations that he is responsible for both shootings. Now, these declarations, these statements against interest, leave no doubt in the defendant's mind who's responsible for the attempt on his life or the attempt on Moore's life. It is the state's theory, Your Honor, that the defendant and co-conspirator Moore conspired to finance the murder in retaliation for the attempts on their life. The state's case is further supported by the subsequent events that occurred afterwards. We heard from Detective Barnes concerning the Unruly Citizens concert. There, Detective Barnes and his partner felt they needed to step in because the violence had escalated to the point that it would be dangerous for the general public. Again, the event in of itself is not 404B evidence, but what we do get is the defendant's admissions after the event, right? And the court got to see his social media post right afterwards. That goes directly to motive, and it is further evidence of ill will between the parties because he says it in, if you recall, everything is not sweet on this end regarding his relationship to the decedent. Right after the concert, Your Honor, we have the V-Lad interview where we get to see the defendant or hear him attempt to say that he doesn't know who the decedent is, right? And then we get a good insight into his beliefs concerning forgiveness and his need to get the lick back. These admissions are pure motive evidence. After that, we have the defendant's attack on Rainwater, the decedent's manager. Then Moore is shot again. This time he's shot in the leg. Again, the shooting of Moore is not 404B evidence. 2 weeks later, the decedent is ambushed by Moore's associates at V-Live in Houston. And then 2 months after that, we have the murder. This timeline event goes directly to 3836 evidence about the prior relation. It's contextual evidence concerning an ongoing feud.
I told y'all that V-Live shooting was the niggas from out of town. They tried to blame it on Rap a Lot. I told y'all that. Coffee is the one that said that from the get-go.
And it goes to show the motive of the parties. And the jury should be entitled to know what transpired before. And the state has a great need to show its case on motive, as well as to corroborate some of its witnesses' testimonies. Since the majority of this evidence is not 404B evidence, the state plans to introduce most of this evidence contemporaneously with state's witnesses as they testify to the charged offense. And when we look at ultimately the amount of evidence that's going to be produced concerning the feud, it will be negligible in comparison to the amount of evidence that we're going to put on concerning the murder. Your Honor, this evidence, the feud evidence, is not unfairly prejudicial. Regarding the rap music, no Texas court or federal circuit court has ever drawn a bright line concerning rap music. The CCA in Hart and almost every federal circuit court, but I cite to the Sixth Circuit in Stuckey, recognize that rap music is highly prejudicial. But despite that recognition, they still conduct a 403 analysis. In my recent filed response, I cited to 2 recent cases. There are only 2 cases from Texas since Hart. It is Brown and Williams, Texarkana and Fort Worth. Both of these courts adhere to Hart, recognize that rap music is highly prejudicial, but still conducted their own 403 analysis. And in those cases, their lyrics were found to be more probative than prejudicial. While we don't prosecute individuals for rapping about music, Your Honor, in a murder prosecution, the lyrics can be probative where they speak to the murder, the feud, the party's motives. You heard from Detective Barnes, lyrics do not drive his intent.
Quantum Fiber Internet celebrates how you run the meeting, run the house, run 3 screens at once, all powered by
the lyrics. Even Dr. Nielsen conceded that sometimes events in lyrics can be true. Last week we heard about rap music concerning how it depicts and glorifies criminal activity and violence. And it speaks to and depicts guns, drug trafficking, the gang lifestyle, degradation of women, foul and overly aggressive and sexually explicit language. But the songs that the state has selected do not contain all that. In fact, they are braggadocious about criminal activity, but the criminal activity mentioned is directly on point to the charged offense. They talk directly about placing bounties for reprisal. They talk about the murder, and they talk about the feud. In fact, all but one of the cases, Your Honor, reference directly to the decedent. Hit Us, the first case, the first song, this is the one that does not reference the decedent, but the court heard from Detective Barnes why it's important. During this feud was the first time the defendant ever talked about placing a bounty on someone. Then we have Keeping in the Streets. Grand jury testimony shows that this song is a direct response to the civil suit. The timing of that song, the context of the song is probative. It goes to the ongoing feud, it goes to motive, and it shows the escalating violence between the parties. On Your Head. This song is directly on point to the charged offense. Both Moore and the defendant talk about placing bounties for reprisal, and Moore takes it one step further. He says he's put 50 bags on the decedent. Grand jury testimony will show you that this song is eerily on point to the charged offense. Now, defense is going to argue that Moore's lyrics in that song shouldn't come in because he's not a co-conspirator. Well, Moore's lyrics come in for two other reasons. One, it's a statement against interest. And two, it's an adoptive admission by the defendant. These are commercially produced songs and performed by the defendant. He has full editorial rights, and the fact that he kept it means he adopted it. Take 3, Mo 3, Take 3. The title, the subject matter, the mockery of 219 in it, or the mimicry of 219. The timing is so probative in this case, Your Honor, because hours after the murder, the defendant text messages this song to a co-defendant, Jerry Johnson. And this song directly references the decedent, the murder, and placing bounties for reprisal. Equally as important.
When he say he texts that song to the co-defendant, Jerry Johnson, boy, they got some stuff going, don't they? Boy, they singing like a bird up in there.
As probative, Your Honor, is Gassed Up. We saw evidence that it was composed days after the murder. It appears not to be finished, according to Detective Barnes. But just the same, it was text message to Jerry Johnson. Again, another never-before-released song. It speaks directly to the feud, the murder, and contains threats of continued violence towards HMS associates. Next, we have the co-conspirator songs. Hypocrite, Laugh Now, Sure. We heard from Dr. Nielsen. He says that these are celebratory songs of the murder of Mo 3. Here, Moore lists out several autobiographical events, and when he does it as justification for the murder, as well as he outlines certain details of the murder in all three cases. This is probative of retaliatory motive and goes to the conspiracy. In fact, Laugh Now is probably the most important of the three because this is the song that he previews to the defendant during that Instagram post call live, right? And we get an opportunity to see the defendant's facial expressions as he's listening to the song.
Was that 88? It just got up and walked by to the other side while they hold up, y'all, hold up.
Song,
hell no.
as he's reading the follower comments. It appears not to be finished, according to Detective Barnes. But just the same, it was text message to Jerry Johnson. Again, another never-before-released song. It speaks directly to the feud, the murder, and contains threats of continued violence towards HMS associates. Next, we have the co-conspirator songs. Hypocrite, Laugh Now, Sure. We heard from Dr. Nielsen. He says that these are celebratory songs of the murder of Mo 3. Here, Moore lists out several autobiographical events, and when he does it as justification for the murder, as well as he outlines certain details of the murder in all three cases. This is probative of retaliatory motive and goes to...
That was 88. So you got up during the trial, 88? Wait, hold up. Let's go back. Right. Because what am I on? Let me see. 40, 36. Let me see.
Associates. Next, we have the co-conspirator songs. Hypocrite, Laugh Now, Sure. We heard from Dr. Nielsen. He says that these are celebratory songs of the murder of Mo 3. Here, Moore lists out several autobiographical events, and when he does it as justification for the murder, as well as he outlines certain details of the murder in all three cases. This is probative of retaliatory motive. And
88, that's definitely you. That's definitely you. Hell yeah. Man, how the fuck you bring this back? Hold up. I ain't trying to go too far back.
as well as he outlines certain details of the murder in all three cases.
You got during the
This
trial.
is probative of retaliatory motive. And
Definitely you, 88. God dang, I missed it again. Turning my damn head. God dog, hold up. That's you, 88. I don't give a damn what nobody say. We finna catch it too.
as well as he outlines certain details of the murder in all three cases. This is probative of retaliatory motive and goes to the conspiracy.
And it's that 88.
In fact, laugh now.
That's her. That's 88, ain't it? What y'all think, man? Is that 88? That's 88. She got up during the goddamn trial. That's what she did. She didn't move before the trial, before they started the pre-trial. She got up while they was. I'm surprised they didn't kick her motherfucking ass up out of there.
Now it's probably the most important of the three because this is the song that he previews to the defendant during that Instagram post call live, right? And we get an opportunity to see the defendant's facial expressions as he's listening to the song, as he's reading the follower comments, and it reeks of consciousness of guilt.
713, did you see that? That was 88. Man, I know you know your own girl now. Wasn't that 88? She left during the she got up and switched sides during the goddamn pre-trial, not before the pre-trial. During it, why they was up there talking? I'm surprised they didn't kick your ass. Move up out of there.
Now, in that situation, the state wouldn't be admitting that song for the truth of the matter, sir. It would go to his state of mind, consciousness of guilt, and motive. Authorship. Defense raises the issue of authorship concerning these songs, yet in their motions, they concede that these songs are artistic expression of the defendants, and that's because they're raising a First Amendment claim. You don't have First Amendment rights to words that are not yours or speech that isn't yours. More importantly, if we look at the cases where authorship is called into question, it is not commercially produced songs performed by the artists. Authorship is not an issue here, Your Honor. This case is about Dallas rappers airing out their beef with their music. Rap music is part of this case, Your Honor. It is not a side feature to distract or mislead or confuse the jury. And we aren't doing it just to impugn his character. Rather, the lyrics and the music themselves expose the motive between the parties, the relationship between the parties, and in certain cases explain the events that led to it. As you heard from Detective Barnes, these were not just words, people were dying. He further told us that everyone in this case has been shot. This evidence, Your Honor, is not unfairly prejudicial. Your Honor, the state is going to ask this court deny the defendant's motion in limine and allow the jury to hear the full story, to understand the motivations between the parties, and to understand what transpired that led to this murder. Thank you.
Thank you.
Yesterday at 3:38, I filed a post-hearing brief and I emailed it to the court. Would you like to have a copy of it?
Yes,
May I approach?
yes, sir.
May it please the court, Your Honor, we just heard Mr. Vela say that the evidence they seek to admit isn't 404B2 evidence. It said 404B, I assume it means 404B2. But it goes to motive. One of the exceptions to get in evidence not directly related to the crime, as the court knows, as an exception to 404B2 is motive. So he said that these aren't extraneous acts or offenses, but every piece of evidence the state wants to present to the court that doesn't go directly to the murder of Mo 3 is listed in the state's amended notice of extraneous evidence dated July the 8th, 2026. So now suddenly the state is pivoting away from this being 404B2 or even 3836 as simply being evidence showing my client's motive. It's important for the court, Your Honor, to distinguish between words and deeds and between ideas and conducts. What the rap music in this case are words and deeds of Mr. Conway. This is what he does for a living. You know, some of it, especially what we heard from Devarius Moore, aka Trap Boy Freddy, is distasteful in some people's eyes, but still, they do have a First Amendment right to make the music and to publish it. Can't be punished for exercising a constitutional right. And the three-judge panel in the concurring opinion of Hart stated, Your Honor, singing about drugs, guns, and murder is nothing new. It's as prevalent in our culture as singing about God and love. But what these lyrics and music videos have in common is that they are artistic expressions. Using someone's art in the guilt innocence phase of a trial only as character evidence has the potential of being unfairly prejudicial. That's exactly what the state's trying to do in this case, Your Honor. Now, Hart, another distinction I want to put on Hart, it differs in our case only from our case only in the context of the introduction of the rap videos by the state. Hart was convicted of capital.
Imagine being able to build anything just by thinking about it. Meet Base 44, a complete AI creation platform made for anyone with an idea and a drive to bring it to life. Describe what you want and watch it take shape. You can plan, customize, and expand in any direction. From tools.
They still reversed Hart and granted him a new trial, even though the defendant in Hart took the stand and the rap music that was admitted was as rebuttal evidence. Mr. Conway is not taking the stand in this case. Now, I'm not sure how hard the state's pushing the notion that Mr. Moore, aka Trap Boy Freddy, isn't a co-conspirator. We heard last week Detective Barnes make an analogy with like the CEO of UPS who sent employees out to do things. Mr. Conway is not the CEO of anything. He doesn't control Trap Boy Freddy. He doesn't control any of the individuals involved in this case. What controls whether a person is a co-conspirator is Texas Penal Code 701. That's a co-conspiracy statute that goes directly to the charge or primary offense. What I believe the state's trying to do by trying to introduce all this extraneous evidence is they're trying to peg my client with Pinkerton liability, as I explained on my brief, which is Section 702 party liability. We don't have any Pinkerton liability issues in this case, Your Honor. And I went into great detail about the difference between the two on pages 7 through 9 of my brief. The actual alleged co-conspirators in this case are Jerry Johnson, Keywan White, and Devin Brown. Why? Because they've been indicted. I attached copies of the indictments in the appendix. Under 801E2E, Texas Rule of Evidence 801E2E, their statements, if it's in furtherance of the conspiracy, could be admitted. But they haven't made any substantive statements in this case, which is why the state's not trying to introduce any of their statements. They're trying to introduce every statement, either public or private, that Trap Boy Freddy's made. But again, Trap Boy Freddy is not a co-conspirator. He's not a co-conspirator under Section 701. They're trying to allude that he's a co-conspirator under Pinkerton liability and Section 702, but there's no evidence of it. They introduced no evidence. Detective Barnes himself stated, he testified under oath that at this time, there's no probable cause to arrest Trap Boy Freddy. And we keep hearing about a conspiracy and the state's attempt to introduce songs and statements made after Mo3's murder. The law is clear, Your Honor, as I point out on pages 11, 12, and 13. The alleged conspiracy in this case ended on November 11, 2020 at about noon when Mo3 was murdered. Nothing said or done after that is evidence of the conspiracy unless it's for concealing the alleged crime. Now, does the state allege that anyone involved, whether as an actual or alleged co-conspirator, did anything to conceal? No, the state is alleging the opposite. That they didn't just conceal it, they did the opposite. They sang about it. They went public about it. Those statements cannot be admissible, Your Honor, as I point out, under 801 E2E, because the conspiracy, if anyone existed, ended on November 11, 2020 at noon. And further, there's a lot of case law on this that I point out on page 13 of my brief. The statements made by the various individuals in this case through rap music or through Instagram posts or Facebook Live posts, they're not in the furtherance of a conspiracy, Your Honor. They're inadmissible hearsay, and what they are is, there are four types of statements that numerous Texas courts and published opinions have stated are not in furtherance of any conspiracy. Listed on page 13. The first one are casual admissions of culpability to someone the defendant had individually decided to trust, mere narrative descriptions, mere conversations between co-conspirators, and puffing or boast by alleged co-conspirators. Now, this case has a lot of puffing, has a lot of boasting, but that's all it has. Those statements specifically are not admissible as statements of co-conspirators. Next, Your Honor, we heard Detective Barnes make a comment that Mo3's interview with Cam Capone on April 6, 2019, which was a little over 18 months before his death, was as close to a dying declaration as we can get. I asked the court to order the state to instruct Detective Barnes that he cannot say dying declaration. That was not a dying declaration, Your Honor. A dying declaration is controlled by Rule 804B2. And one of the important aspects is that the declarant must have realized that he was at death's door. Now, we don't know exactly, obviously, what was going through Mo3's mind. Detective Barnes speculated and said that, well, he, had a general bad feeling that, he might get hurt in some way sometime in the future. But we don't know what else type of conflicts Mo3 was into. He was a rapper. He was a provocative rapper. The evidence shows that he manufactured the beef, largely manufactured the beef with Mr. Conway for commercial purposes. That's, we heard from Dr. Nielsen, that's what these individuals do. They make up beefs, they manufacture them to cause controversy. Why? Because, Your Honor, controversy sells. An uncontroversial, friendly person usually isn't an interesting person. In our society, especially with social media and music, it's the edgy person, the person who says, say crazy things sometimes. That's the person who's interesting. That's the person who draws attention to himself. That's the person that people will pay to listen to. That's what was going on in this case. Now, the state cites several federal cases, Your Honor. I argue that the reliance on those federal cases are misplaced because, number one, those cases are not binding authority, and none of the facts of those cases support the state's contentions. The main three ones that I pointed out in my brief, Your Honor, are Perry, Campbell, and Alvarez. Perry, the relevant page is attached in the appendix, page 8, Your Honor. It's a 55-page opinion. I only attached the first page, and the relevant page I just want to read from Perry. The general conclusion from courts is that this type of evidence, meaning explicit rap videos and lyrics, are probative and outweighs substantial prejudice when the defendant performs the songs, describes events closely related to the crime, and the evidence is not cumulative. Okay? Here, simply rapping about something regarding a beef is not rapping about some facts that are closely related to the crime. Now, if someone in this case, Mr. Conway, for instance, had actually rapped about facts that go to what we believe that the grand jury witness may come to court to testify to, those specific facts that led to that, then yeah, that would possibly be admissible. We don't have that in this case, Your Honor. Rappers make songs about putting hits on each other. They make songs about bounties. Again, it goes to the edginess and, in some people's opinions,
The video is too quiet? Boost your volume up to 600% with Volume X. Your browser caps audio at 100%, but your speakers, they can do 6 times more. Just click to add. Simple to use.
In the crime. And in Campbell, Your Honor, which is actually the case that Detective Barnes testified to that he was involved in, that wasn't the Fifth Circuit opinion, Your Honor. That was from the Northern District of Texas. Campbell, Your Honor, the issue regarding the admission of rap music was about punishment. That was a punishment issue. I don't believe it's relevant at all because here the state's trying to get into this evidence during the guilt innocence phase. And then Alvarez, Your Honor, which is also cited by the state numerous times in this brief, the issue was the admission of corrido music. It's a kind of sort of, I guess, it's sort of like Mexican folk music. And that was admitted because the song in question memorialized a trip during which the drugs were tendered, was cooperative of the testimony of cooperating witness, and there was no objection to the admission of the song, which means that the Fifth Circuit review was for plain error. Plain error, Your Honor, goes beyond the scope, but it's almost impossible to overcome the plain error exception to Fifth Circuit appellate review. Now, the Texas case is relied upon by the state that Mr. Vela mentioned, Williams and Brown. First off, both those cases, Your Honor, were unpublished. They have no precedential value. I just want to point out 2 brief issues with each case that I think are most relevant. In Williams, Your Honor, one witness testified that they had made between 8 to 12 rap songs about the murder. So in Williams, Your Honor, during the trial, the state put a witness on the stand who testified that he was either there or he helped the defendant make these videos or write the lyrics to these videos between 8 to 12 that discuss specific facts of the murder. We don't have anything like that here. What we have instead is Detective Barnes speculating about what the meaning of the lyrics are, which, as you heard Dr. Nielsen say, that just isn't possible because then you would have to assume that Detective Barnes can get into the heads of the rappers, which of course he can't do. And then in Brown, Your Honor, the rap music was admitted, but it was admitted only after Brown got on the stand and testified that he didn't know the reason about his father's relationship with the woman, which was the state's theory about why he paid money to have his own father killed. He said that he wasn't angry about the relationship and he didn't know why his father died. Well, all that was rebutted by other witness testimony and also his own phone calls he had made from the county jail.
Man, this is deep, man. Did y'all just hear that? Man, people gonna be see these blogs. I'm telling y'all gotta listen at the people, man. The people they letting you know what's really going down. See how many bloggers is wrong?
Here, Your Honor, again, I keep going back to it, but it's important to note Mr. Conway has not testified. Now, if he gets on the stand and makes certain statements that he has no idea about why anyone's saying that like a certain song he made has anything to do with Mo3's murder, then yeah, under impeachment, the state may be able to get into that, but he hasn't done that yet, Your Honor. So I asked the court at minimum to hold off on admitting any of the rap songs that Mr. Conway made until we get to the point where it would maybe be admissible because he gets on the stand and testifies. Now, the state is also trying to get into this evidence during the guilt innocence phase, Your Honor, under Article 3836 of the Code of Criminal Procedure. It's important.
Did y'all hear that? Did y'all hear that? Meaning Yella basically said they definitely ready in case Yella gotta hit the stand. His client will hit the stand. See, look, I think a lot of stuff gonna come out this trial, man. I'm telling y'all, man.
Important to note, Your Honor, that as clearly stated in Garcia, it's cited on page 21, evidence under Article 3836, especially if it has to do anything about violence between the decedent and the defendant, it still has to meet the requirements of Rule 404 and 403. You know, it's not 3836 isn't an end around to admit evidence of unsolved feud cases, drill, rap music, or other alleged bad acts without the evidence being subjected to 403 and 404A1 and 404B2. We just heard the state, Ms. Avella, say that this isn't about 404B2. It's not about 404B2. Then, you know, again, these are unadjudicated cases for which the state, the police, don't have probable cause to arrest anyone, and the state's trying to get into it during the guilt phase of this case. Now, we heard Detective Barnes testify last week, Your Honor, about you know these shootings and how the shooting of Roy Pate started a feud, and we also had evidence of James Browning's murder talked about, and DeJuan Spike's murder, and the shooting of a third individual in the case, Robert Gua being shot. Now, other than the murder of DeJuan Spikes, for which someone already pleaded guilty, in Criminal District 4, Your Honor, in front of Judge Collins, Randall Hunter, and cause number F19-76608, pleaded guilty to the murder of DeJuan Spikes and received 20 years in prison. The state already has their defendant in that case. To say that, without there being any probable cause that Mr. Conway had anything to do with these murders, it's so prejudicial to allow evidence of these murders into the guilt phase. Because again, there's no evidence that Mr. Conway had anything to do with it. Just because he may be tangentially associated with someone the state thinks may have done something in those cases doesn't make it admissible under any exception in this case during the guilt innocence phase. And then, you have the September 1920 shooting at V Live in Houston where Mo 3 was doing a show. In that case, as Zontavious Davis was shot in the head, Davis was one of the ones who ambushed Mo 3. Now, even if Davis is associated with Trap Boy Freddy's record label, which is how the state is associating Davis with Mr. Conway, this has nothing to do with Mr. Conway. Again, Mr. Conway didn't direct any of the actions and misfeasance on September 19, 2020. He doesn't.
That's proof that Coffee was right about the V Live shooting. I did so many lives telling y'all because they was trying to blame that on Rap a Lot. I told y'all them people came from towards D-Town and Funky Town from Mo 3. They had to come from there because Mo 3 was in the streets like it wasn't nothing in the city.
To control these people. There's no evidence that, again, he is some sort of lead. They're trying to pin Mr. Conway as some sort of leader of a gang. He's not a leader of a gang. He's not in a gang. He's never been accused of, credibly accused of being in a gang. They, had pictures of this trap house in Oak Cliff that co-defendant Jerry Johnson owns. That Keenwan White was seen in some of those pictures, and Theodore Thomas was seen in some of those pictures. Mr. Conway, Your Honor, has nothing to do with that trap house. There's no evidence that he went there to hang out, that he went there to deal drugs, to ingest drugs. I mean, that sort of evidence, Your Honor, is so prejudicial. And of course, you know, with Detective Barnes on the stand speculating about the meaning of pictures, we heard a lot of that on Thursday and Friday. Of course, any reasonable juror is going to think, well, is Mr. Conway involved in that? If Mr. Conway might be involved in all these unadjudicated shootings for which Mr. Detective Barnes says that there's no probable cause to show that anyone's been charged or arrested, you know, they're going to think, well, if he may have been involved in that, maybe he did cause Mo 3's death. That's why.
No, so right now I'm not gonna lie, y'all. The defense, he putting up a good argument. He putting up a great argument. Straight up. I'm listening to him. He putting up a good defense.
As the gatekeeper, Your Honor, we ask that you keep this evidence out during the guilt innocence phase. Now, the Unruly Citizens Concert of July 27, 2019, that the state seeks to admit to show the beef between Mo 3 and Mr. Conway, that was a strange one. You know, again, logically, you know, if Mo 3 was really booked for the show to appear on stage with Conway, he would have entered the venue through the entrance that performers and the crew enter, not live stream themselves walking through them to the main entrance, you know, where he was arrested. And also, you know,
if a tow truck driver recommends a lawyer at an accident scene, stop. That's a crime in Nevada, and insurance
had anything to do with Mo 3 being denied entrance into the venue. In fact, you heard Detective Barnes testify that he was concerned about Mr. Conway and Mo 3 being on the stage at the same time, so he contacted Frisco PD, and they affected him being Mo 3 being stopped from entering the venue. They affected his arrest.
One moment. Who are those standing in the back? I'm going to need y'all to sit down, please. Find a seat.
Now, you have copies of all the videos and all the lyrics that state wants to get into. I'm not going to go through every single one, but I start on page 25, 26, and 27 of my brief. We argue that no evidence of the rap music credited or sang by Mr. Conway or anyone else is admissible during the guilt phase. Going through the state's amended notice of extraneous evidence dated July 8th, there's no evidence supporting the state's or Detective Barnes' contention that, you know, the song Six Pick, from October 20th, 2017 had anything to do with the planning of the murder of Mo 3 or, you know, with the beef that, again, Mo 3 largely manufactured for his own commercial benefit. During the hearing last week, you heard Detective Barnes, Your Honor, say for an instant that, you know, Mr. Conway is largely, you know, like a local rapper. But then on cross-examination, Mr. Shook got Detective Barnes to admit that no, actually he already had a big national following. That's why Mr. Conway, is going to places like Los Angeles to do recording. Local rappers usually aren't invited to Los Angeles and New York to make rap music in numerous studios. And all these songs, Keep It in the Street, Love I Had, A Guardian Angel, none of them have anything to do with any motive or any other exception, contextual or otherwise, about the murder of Mo 3 on November 11, 2020, Your Honor.
From what I'm hearing, they trying to get them songs to right, you know what I'm saying? Where they can't use none of them lyrics or none of that against him, because he basically think that's all Detective Barnes got. But we all know they did have some kind of money transfer, wire transfer or cash transfer or however it went. So we're just gonna we're gonna pay attention to them and not as much as the sector, man, because they saying a lot of stuff that we miss.
And like on the January 27, 2021 song, Hypocrite, where Trap Boy Freddy is mocking the death of Mo 3, again, Your Honor, that's not evidence that Mr. Conway or any alleged co-conspirator, the three other indicted gentlemen, caused Mo3's death. It doesn't fall under any exception to 404B2. It doesn't fall under 3836. Again, these songs, it's true that a person, Mr. Vela said this earlier, it's true that a person doesn't have a First Amendment right to music or any expression that's not his own. However, these expressions are at least partly Mr. Conway's, and he can't be punished. Like if he wrote a song, the lyrics for a song, he can't be punished for expressing them, especially here commercially. And no evidence of the interviews of other social media posts are admissible during the guilt phase, Your Honor, like the live stream from the evening of Mo3's death. And for Detective Barnes to sit up there and say in front of the jury, well, he doesn't seem bothered by it. Well, Your Honor, Detective Barnes doesn't know Mr. Conway personally. He doesn't know how certain people react to a person's death. And I mean, and Mr. Conway and Mo3 weren't friends. Usually people that are upset about that someone's death, it occurs that they knew them and had some affection for them. Here we have a case where Mo3 largely manufactured a beef against Mr. Conway because he saw Mr. Conway as one of the premier rappers in the Dallas area. Dallas is one of the largest metropolitan areas in the country, so that made Mr. Conway, especially after he went national, one of the premier rappers in the country. Obviously, Mr. Noble, Mo3, has a lot of motive to manufacture a beef with one of the top rappers in the country. And that's what happened here. And that's all that happened. And finally, Your Honor, as I point out on page 29 and 30, if the court takes the state's amended notice of extraneous evidence dated July 8, 2026, and runs them through the Montgomery and Giglio-Bianco tests, the court should find that none of it is admissible, and even any of it that might come close to a line of admissibility, the prejudicial effect far outweighs the probative value to admit this evidence during the guilt innocence phase and before Mr. Conway takes a stand, if he takes a stand. And also, I just briefly mentioned, Your Honor, on page, we didn't really do a 702 hearing, but if the court construes last week's hearing as a 702 hearing, Detective Barnes, Your Honor, isn't qualified to provide expert testimony about the meaning of videos, interviews, and social media posts unless a much stronger foundation is laid for the evidence, because frankly, his testimony is nothing more than personal opinions and narratives. Detective Barnes admitted, Your Honor.
So I'm gonna tell y'all what I think gonna go on. This is what I think, and this is my theory only. From what I'm hearing, he got a good defense. You know what I'm saying? It's a possibility they could let them beat that state and the feds roll everything over. You know what I'm saying?
He received little to no cooperation from people on the street about Mo3's murder. He said that on the stand. He couldn't get evidence or witnesses, so instead he went to YouTube, started looking for evidence to match what he believes happened in this case. Detective Barnes' belief isn't evidence, Your Honor. And he also admits that this is the first time he's worked a case like this, where he's broken down rap lyrics line by line and tries to offer opinions on the meaning of lyrics. Now, as the court knows, jurors place great weight on expert testimony, and the trial court has a heightened responsibility to ensure that expert testimony is both relevant and reliable. We believe that Detective Barnes is allowed to testify before the jury, as he did here, that the jury will place great weight on his testimony and believe that his personal opinions about the meaning of lyrics and about what Mo3 was thinking during the Capone interview is actual fact, and it's not fact. And that's all I have, Your Honor.
Thank you very much. All right, if either side wants to submit a proposed.
Now, Your Honor. Mr. Vela sent me a proposed order regarding defendant Conway's amended motion to eliminate. I made some corrections on there, and Mr. Bella agreed to those corrections. I'm going to tender to the court a document entitled Order Regarding Defendant Conway's Amended Motion in Limine. This, let me just tender it to you. This has each of the alleged extraneous offenses, Your Honor, listed on there, as you see, and it gives the court the option of granting our motion, thus precluding it, granting in part where the court decides that you're going to allow like certain parts of the song or certain parts of the view, or denying in full. And those are the ones that the state, and each one of the dates should match what's in the state's amended notice of extraneous evidence, Your Honor.
And both sides are agreeable to this form, correct?
Yes, Your Honor.
Okay. Is there anything else?
Nothing from the defense, Your Honor.
Nothing from the state, Your Honor.
That concludes this hearing. Thank you.
Thank you.
What he basically had for y'all was he had all this basically sit together. He had all the judiciary, because y'all know they in codes and all that. He had all of that shit showing that this is what violates the, state government law, all of it. This is what violates. This is what they trying to use. This is where it's saying that this shouldn't be admissible in court. He a good lawyer. I ain't gonna lie. He a good lawyer. He might be a little slower because he got older. But I could tell, man, back in his days, he had to be sharp. He a smart lawyer.
How are you?
Doing well, how are you?
He's on bond, Your Honor. He just wasn't enough room for him. He's on bond, there wasn't enough room for him.
All right, let's do it again.
He was in here, he went to get his client once there was more room for his client to come in.
Good morning. Good morning, Judge.
How you said?
I'm doing well.
I hope not, but just in case. It's out there. Where am I?
I just wanted to see everybody that had came up out of that. That right there, man. Shit, that lets you know right there what they got and what they don't got. Everybody been talking about what they got. So it don't sound like they got too much, but them lyrics, man. Sound like they got them lyrics against them. That's the only basically thing Barnes done put together, besides whatever deposit, money transfer, or whoever said what. You know what I'm saying? And that's gonna come out in court. Because whoever said all that, they gonna have to hit the stand and say it in front of the jury. They gonna have to persuade them without that music. That's what that lawyer trying to do, get all that music and stuff out of there where they can't use it because you don't supposed to. But in my all of it, before I get up out of here, my all of it, if Yella them do beat that, It's because the feds gonna pick it up because Trap Boy was definitely on that freeway, and the feds can prove Trap Boy was on that freeway. They can prove that he knew stuff ahead of time by the stuff he was saying. They can use them lyrics. They can use whatever they want to use and put together whatever theory they can to rake all of them up. That's true. That's very true. Y'all see, Boosie had beat this guy, and what they do, feds picked them up. You know what I'm saying? In this case, it'll definitely happen. For sure, for sure. Because Trap Boy name all in that courthouse is in there. Y'all heard what they were saying about him. So everything gonna come out. Everybody just sit back and chill. That trial, this gonna be the biggest trial in Texas. I'm from Texas. I know this gonna be the biggest trial that ever hit Texas just on forefront. Now we done had a lot of worse shit that happened down there before, celebrity wise, because that's what Mo3 was, celebrity. That right there is gonna be along the attraction to this trial because they want justice, and anybody that may have been involved or blamed for it, and if they wasn't, hopefully they can get cleared if they ain't have nothing to do with it. We're gonna sit back and we're gonna see what they talking about. We're gonna follow the trial. That's for sure, man. Hey, I salute everybody that tuned in to Coffee Time, man. Y'all make sure y'all hit that like button, share the live, because this trial is gonna get real deep. You're gonna see a lot of stuff come to the forefront. A whole lot of stuff. It's stuff all up in there that most bloggers have missed. Queen 88, we seen you walk by the camera and go sit over there by Yella Beezy too, man. We know that was you. That's what they was talking about. And you got up while I'm surprised that judge ain't tell her to get out. I ain't lying. I'm surprised they didn't tell her to get out, because you supposed to be seated whenever everybody see you. Supposed to stay seated. You know what I'm saying? She got up while the lawyer speaking to the judge, breaking his case down. I just don't understand that. It ain't that much clout chasing in the world, man. But it is what it is. It is what it is. I don't knock nothing nobody do. That's for sure. You gotta do what you gotta do. But the thing of it is, watch how you do it. You know what I'm saying? Right now, 88, you looking like you playing both sides. That's why Rainwater don't trust you no more. You know what I'm saying? He don't trust you no more because you straight up got up from Mo3 side and went to Yella them side. That was so disrespectful. And that's all Coffee got to say. You know what I'm saying? I'll get back with y'all later on, man. I'm out.